Music. The timing was a little bit suspicious. Well, welcome to another very sunny day in Monterey Bay.
Sorry. I'm glad you're my friend.
That's quite all right. We could go on. So as Lloyd indicated, I've been asked today to address the judge's perspective on the function of the civil grand jury. As you know, by law, in each of our 58 counties, the Superior Court is responsible for the recruitment of the grand jury, for appointment of the foreperson, for providing orientation mainly by the charge at impanelment, for review of final reports, as well as for the handling of misconduct by or conflicts between grand jurors during the course of the grand jury's life in any given year. Because of that interaction, I agree that it is useful for you to have a sense of the perspective that the presiding judge brings to grand jury activity. I say presiding judge.
We can't hear you back there.
I say presiding judge. That was Karen Hearn, that wasn't Metzi. Just so you know. And I remember all of this. So, I was about to say that I mentioned the presiding judge's perspective, and the reason for that is that the presiding judge in most counties is the judge that the grand jury will interact with. In some of the most populous counties, the presiding judge makes an assignment to a supervising judge for that particular function, but in the majority of counties, it's either the presiding judge or the assistant presiding judge. So an initial question arises in exploring the perspective of presiding judges. Who are they? Where do they come from? What's their background in the law? In California, generally, to be a judge, a person must be licensed as an attorney and in good standing with the state bar and have been in practice for at least 10 years. Superior court positions in California are elective. Judges are elected to 6-year terms, but most vacancies that occur on superior courts throughout the state are filled not by election, but by appointment of the then sitting governor, because the law provides that if any vacancy occurs other than at the very end of the 6-year term, in other words, somewhere in the middle of the term, the governor fills the vacancy with an appointment. The appointee then stands for election at the conclusion of that term. Interestingly enough, well more than 90% of vacancies are filled by the governor's appointment process. And that appointment process has become increasingly extensive over the 30 years that I've observed it. Each governor during that period of time has seemed to add steps and, frankly, more rigor to the evaluation process. There's a formal process that you'll find in the code books, and then there's an informal process that recent governors have all used. The formal process begins with an extensive application that's filled out by a person who's interested in an appointment to the Superior Court. And that application these days literally takes days to complete. It's submitted to the governor's judicial appointment secretary or appointment secretary, as the case may be, for review. And then, as to applicants whose prospects appear interesting to the governor, those applications are sent to a specially created state bar commission for vetting. That commission will involve itself, first of all, in the exchange of extensive questionnaires with members of the bar association from which the applicant comes, and review the application material in detail, and ultimately interview applicants who appear promising. Simultaneously, this informal process also goes forward. The governors in recent times have appointed regional committees on an informal, confidential basis of attorneys and judges from those regions. And the names of applicants are provided to them, and they are asked confidentially and informally to vet those applicants, once again, frequently by contacting lawyers and judges within the specific jurisdiction at hand. In the end, both the formal process and the informal process result in reports made to the governor's office that are again fielded by the judicial appointment secretary. And ultimately, the judicial appointment secretary will personally interview applicants that are thought to be finalists for a job. The outcomes are that the appointment usually takes place many months, even up to a year after the vacancy's been created. It's that extensive a process. Appointees usually come from the local bar association where the vacancy exists. And these days, appointees are drawn more or less equally from the civil litigation bar and the criminal bar in the jurisdiction. There are some business lawyers, but mostly courtroom lawyers, which of course include family law attorneys, are the applicants who succeed in gaining an appointment. Overall, even though the process ends in a governor's appointment, the system is not one of cronyism. Certainly the governor's philosophy is reflected in the process, but it generally produces able, thoughtful, neutral judges, at least in my experience. Interestingly enough, a number of years ago, a study was performed to see what, if any, difference occurred in the performance of judges who were first on the bench on account of an appointment as distinguished from those who stood for election at the end of a retiring judge's term and actually gained office by the election process. And that was by reference to the judicial discipline process that is conducted in our state by the Commission on Judicial Performance. The study evaluated judges who were formally and publicly reproved or otherwise disciplined and the source of their beginning their work, and it was discovered that appointed judges were far less likely to be disciplined, interestingly enough, than judges who had first gained office by election. So the bottom line is that in California, to a considerable degree, we have what may be called a merit selection approach to judges going on the bench. So that's where judges come from. Since the grand jury's contacts are with the presiding judge or assistant presiding judge principally in most counties, it might be useful for you to know what the PJ or presiding judge job entails. A PJ is elected for either a 2 or 3 year term by his or her peers, meaning by the other judges in that court. Different courts, of course, take different approaches to making that election. Some, particularly very small courts, actually have a rotating process, sort of everybody has his or her turn in the barrel, so to speak. But in most, it's a competitive process of one kind or another. However, what's universally valued is a person who is collegial and a consensus builder, because the judge side of the court is not a hierarchical organization. Each judge has the same constitutional authority. Each is a constitutional officer. And power and authority doesn't increase with seniority. A presiding judge, therefore, serves at the pleasure of all the other judges in the court, and a dictatorial approach to the job is counterproductive. Interestingly, you might note the similarity here between the foreperson and his or her relationship with the grand jury and the presiding judge and his or her relationship with the judges on the bench. Neither is a hierarchical organization. Both are organizations involving a group of peers. So, more frequently than not, the presiding judge that you may have contact with, you will discover to be a person who works well with others. Well, what are the duties of the presiding judge? The presiding judges overall have responsibility for the performance of their courts. One of the key functions of a presiding judge is to organize and then staff the court calendars. Let me explain by way of a bit of a digression. Except in the very smallest of courts, 2-judge courts or 3 or 4-judge courts, the business of the court is organized by case types. Criminal misdemeanors, criminal felonies, civil long cause cases, family law, estate and probate. Those areas are broken out into separate specialization areas. And there are pretrial calendars that are developed for each to process the cases from the time they first are filed until the time they're ready for trial. The objective, obviously, is to resolve the cases in advance of trial by settlement as the case winnows its way through court. And were we not to do that, all courts in the state would immediately be swamped. So judges are assigned by the presiding judge as supervising judges for these individual calendars. And the judge who is making those determinations, the presiding judge, has to consider the temperament of each of the judges, that judge's expertise, experience, and also preference, because some judges are very interested in taking a particular assignment and not interested at all in others. It's a balancing act. A judge who may have the temperament that commends him or her to handling the unusually emotional challenges of the family law calendar may not have the expertise to handle a felony calendar, for example. A judge who has the background and experience in handling a complicated civil law and motion calendar may be overwhelmed by the volume of a criminal misdemeanor calendar, which sometimes will run to 100 cases in a morning or an afternoon. So making those assignment decisions is part of the presiding judge's responsibility and a vital part in ensuring that the court functions smoothly. The presiding judge is also responsible to be the court's representative with the statewide judicial branch at large, meaning the Judicial Council of California, which is the governing and policy-making body for our state's judiciary. Frequently, the presiding judges in the state are called upon by the Judicial Council or one of its committees to provide guidance relative to policy-making initiatives with respect to legislation that may be pending in Sacramento, and certainly with respect to budget matters in Sacramento come budget time. Presiding judges will be found in the hallways of the Capitol, speaking with legislators, testifying in some instances relative to those matters. The presiding judge also has relations with local authorities, with the sheriff, assuring smooth prisoner transport to departments that are handling high-volume criminal calendars that involve in-custody defendants, with the Board of Supervisors, perhaps, to ensure that the budget for the probation office that provides vital services to the court in supporting its criminal calendars is sufficient to have enough probation officers to staff those calendars. Perhaps with the district attorney and the public defender relative to the management of those criminal calendars so that they move smoothly, efficiently, and effectively, and once again toward the goal of resolving cases in advance of trial. And with the civil bar for the same reason, to ensure, for example, that the mandatory settlement conferences in civil cases are conducted in a way that's conducive to the resolution of cases. The presiding judge also, of course, is responsible for relations with his or her peers, the other judges in the court. As I mentioned, it's a consensus-building job, and so regularly the judges of the court meet, and the presiding judge essentially is responsible for ensuring that those meetings are constructive. And finally, perhaps most importantly, the presiding judge has the daily and regular interaction with the court executive officer. The court executive officer, of course, is responsible for all of the administrative side of the court. The court reporters, the courtroom clerks, the civil processing clerks, the interpreters, the bailiffs, the people who bring the files in, organizing the calendar events, and ensure that the court works well. It's been said by a prominent academic in this field that the organization of a court is not unlike the organization of a hospital. The hospital, of course, has a medical staff comprised of the physicians who have privileges at the hospital to practice at the hospital, and then the hospital administration, which ensures that all the services are necessary, the supplies are in place, the janitorial services have been performed, operatories are ready when the surgery is scheduled, inflow of patients and discharge of patients is handled in an effective way. Without all of that, the physicians would be worthless when they walked into the hospital in the morning because they wouldn't be able to get any work done at all. So it is with the courthouse setting. The judges are completely dependent on a smooth operating administrative function on the administrative side of the house, which of course employs the vast majority of court staff. So the interaction between the presiding judge and the court executive officer is a daily thing and a very, very significant thing. So those sort of outline the duties of the presiding judge when he or she is serving in that capacity for the 2 or 3 year term that the job holds. Well, what about the workload that the presiding judge has as a judge? Except for the largest courts, courts like Los Angeles, Orange, San Diego, and Alameda, all presiding judges, in addition to their PJ work, have judicial duties. In courts from the smallest up to somewhere between 20 and 30 judges in number, the PJ frequently, if not usually, carries a full assignment load and consequently spends early morning hours, the lunch hour between court sessions, and then the early evening after the court case is adjourned for the day, handling PJ duties. That's sort of an everyday occurrence. So now I hope you have a picture or image of who the PJ is, what the PJ does, and what the PJ's workday looks like. You may ask, and probably already are, what background with grand jury matters does a typical PJ bring to the table? As I mentioned, most judges, when appointed, are drawn from the civil litigation bar or the criminal bar. So we can break it down a little bit. The criminal bar, of course, is comprised of prosecutors, deputy district attorneys, or the district attorney in some instances, and the defense side is comprised of attorneys who work for the public defender's office or are in private practice and specialize in criminal defense. With regard to the prosecutors, there may be some experience of contact with the grand jury. Almost always, though, in its criminal function, associated with the bringing of indictments, or as we learned pointedly yesterday, the occasional accusation to remove a local official from public office. If a prosecutor applies for a judgeship and happens to have had that kind of experience, he or she will have some familiarity with the grand jury, but only in its criminal function, not in its civil watchdog function. Criminal defense lawyers have no occasion to have contact with the grand jury. On the civil side, with some crossover, the civil litigation bar is broken down into what may be called a plaintiff's bar and a defense bar. The attorneys in the plaintiff's bar, as the name suggests, specialize in bringing actions at law on behalf of individuals or entities against others, whereas the defense bar generally specializes in defending individuals and entities that have been sued. In neither instance do those lawyers have any occasion to have contact with the grand jury, with one exception, and that's the county counsel's office. The county counsel, as you know, is the civil lawyer for the county, provides representation and advice to the Board of Supervisors and to county department heads. Also, importantly, the county counsel's office is the primary legal advisor to the grand jury in civil grand jury matters. Moving on to the other areas of specialty, you have family lawyers, lawyers in the estate and probate area, juvenile lawyers, business lawyers. None of them has occasion to have contact with the civil grand jury. So, of all the specialized areas of practice, with the exception of a very few judges who are drawn from county council offices, the typical judge, and therefore the typical presiding judge, has little more knowledge or understanding of the function of the civil grand jury than citizens at large. Now, there is one caveat. Of course, trial judges deal routinely and regularly with trial juries. And so they're involved naturally with issues pertaining to oversight, confidentiality, impartiality, juror contamination, and the like. But all of those issues pertain to the trial jury. And the function of the civil grand jury, quite frankly, remains unknown to most trial judges when they take the bench. So we can see that presiding judges who are new to the job know little about the civil grand jury, and also, due to their workload, have little time to learn about it. That's the bad news. The good news is that the job of judging, while routinely involving substantive and procedural legal principles with which the judge is very familiar and which the judge has mastered, also regularly involves being confronted with legal issues that the judge has never faced before. Judges are used to addressing issues they've not come across before. How do they do it? Well, they can consult the statutes, the books of laws passed by the legislature. They can also consult case law, the opinions that have precedent value issued by the California Supreme Court and the appellate courts. But bear in mind, every time a judge has a question that needs to be answered, for example, a motion filed by a party and opposed by the other party, the judge has to rule and it requires some research. whatever is going on in the courtroom stops while the judge does the research to figure out the answer to the question. If it's a jury trial, the jury gets kicked out into the hallway. The lawyers twiddle their thumbs. Witnesses who have been summoned for a particular time of day to testify have to cool their heels. So the time element in judicial decision-making, particularly involving decisions that the judge can't simply make from memory, as it were, is vital and important concerning how well the court functions and how well the business flows. So going to the statutes and the case law is usually something that judges don't do as a first resort when it comes to a question they're not familiar with. Invariably, they turn to what are called secondary sources or secondary resources, how-to manuals, ready reference guides, and treatises, written for lawyers and judges, some just for judges. There are scores of these reference guides covering the innumerable specialized areas of California law. These guides enable a judge quickly to familiarize himself or herself with a specific area of law, and then, as may be necessary, do pinpoint research of a specific case or a specific statute, shortening considerably the time necessary to get to the bottom of a question, answer it, rule, and move on. So these reference guides are absolutely vital in the success of a judge in handling his or her responsibilities. However, until the last 20 years, there were no how-to manuals, no ready reference guides for the presiding judge regarding the civil grand jury function. My 4 years service as a presiding judge ended just over 20 years ago, and so I can verify that. I had orientation duties, recruitment responsibilities, discipline and other grand jury issues that arose with the 4 grand juries over which I had responsibilities. My sources were the penal code and the telephone. I'd get on the horn with my predecessor presiding judge in my court, and frequently with judges in other courts throughout the state who served as presiding judge and who I understand had background training and experience with grand juries. It was a catch-as-catch-can proposition, as you can imagine. I only wish, back then, that I had had the CGJA training program for supervising grand jury judges. I only wish that the comprehensive CGJA grand jury manual then existed, that the handy CGJA practice guide to supervising civil grand juries was in place, and that the compendium of California grand jury law was in existence. But none of those things existed at that time. They all exist now, and they're of enormous aid to the judges who work with the grand juries. They're the very kind of helpful resource that judges routinely cast about for when confronted with a problem in an area new to them. And the quality of what CGJA provides in these materials and courses is self-evident to the discriminating eye of a trial judge, meaning the judge will be guided by it. In short, for most presiding judges and assistant presiding judges, their perspective on the civil grand jury will be formed or at least influenced by the products and services you provide. Products and services which enable those judges better to assist and guide their grand juries. But your influence on the presiding judge doesn't end there. Because as a consequence of an active, vibrant, statewide CGJA, there are now local county chapters in almost half the counties in our state. Those chapters often assist the presiding judge at the time of grand jury recruitment by advertising publicly for citizens to come forward to serve, by recruiting applicants for grand jury service, by sifting through applications, by checking references given by applicants in their applications, by interviewing applicants, and then by making recommendations to the presiding judge and the judges of the court toward the goal of choosing capable, unbiased members of the community to serve. It wasn't so in my time.